Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We are talking about the H-2Bs, and there's been some new regulations out which will go into effect sometime in late April. So keep that in mind when you are preparing or have your attorney prepare the new H-2Bs. First, let's talk about the prevailing wage. Now, the prevailing wage essentially is what the United States would pay other people similarly situated. So, with the prevailing wage, the employer must advertise the position to all potential workers at a wage that is at least equal to the prevailing wage or higher. Okay, whichever is the highest one, whichever they're going to give, but definitely not lower. The employer must offer and pay this wage to its H-2B workers and its workers in corresponding employment. So you have to show that you're not only paying the H-2B workers the prevailing wage, you're paying your other workers the prevailing wage as well. Now, keep in mind that the regulations do not permit an employer to pay a wage lower than the highest wage required by law. Okay, so that deals with the prevailing wage. Now, you need to request the prevailing wage. So the question is, how do you do that? Well, the employer must request and receive the prevailing wage before filing the job order with the state workforce agency. So the SWA, that's what it's known as short, is the agency that in your state that deals with the employment issue. So for example, in California, it's the EDD, the Employment Development Department. It always goes under different names, but you can't go forward with that until you have the prevailing wage. Now, if the job opportunity involves multiple work sites, then you may need to get two prevailing wages for the different sites. Because, for example, if you work in New Mexico, you're going to be making a different amount than if you work in New York, even if the duties are exactly the same. So you'll want to make sure that you will return the prevailing wage determination, which is known as ETA Form 9141, with its endorsement from the employer. In order to have that, it does take a little while, so make sure you get that done and filed. That prevailing wage will be good for no more than 365 days from the day it's issued, and no less than 90 days. So that is the time period for the prevailing wage. As far as retaining the documents, the employer must keep these documents for 3 years from the date of issuance of the final determination of the prevailing wage, especially if there's a notice of deficiency or a request for evidence. If something like that happens, then you need to make sure to properly submit and get the prevailing wage going. And so that's the way that the prevailing wage issue works, and you need to make sure that it's right on the money, what it should be, or else the whole case could be denied. Okay, more in the